Hello, everyone, and thank you so much for tuning in to Constitutional Accountability Center's 12th annual Home Stretch at the Supreme Court event. My name is Elizabeth Wydra, and as president of CAC, I am thrilled that you can join us as we look back on the Supreme Court term so far, look ahead to big cases still to be decided, and discuss the legal landscape against which all of this takes place. We gathered together today at a perilous moment for our country. In its first 100 days, the Trump administration has launched unprecedented attacks on immigrants, trans Americans, federal employees, academic freedom, the guarantee of birthright citizenship, the independence of government agencies, international aid, law firms who advocate positions President Trump opposes, basic science and public health, principles of equity and inclusion, accurate representations of history, congressional appropriation power, the list goes on and on. In the face of these attacks and the legitimate fear and worry they have created, there are those who say that the courts will not save us. And that is true at a fundamental level. The ultimate destiny of American democracy lies in the hands of we the people. The Constitution is enduring, but not invincible, and it is ultimately up to us to keep it as a tool of liberation and progress rather than one of oppression and authoritarianism. Nonetheless, the courts unquestionably have a vital, essential role to play in this moment. They can serve as a bulwark of liberty for individuals targeted by the power of the executive. They can serve as a check on unlawful executive power grabs, serving the role the judiciary is entrusted with by our constitutional system of checks and balances. They can stand up to unconstitutional, unlawful administration actions and enforce democratically enacted legal protections to the fullest, acting swiftly and courageously to defend the rule of law. The courts can and must serve as a guardrail of democracy. Some of the legal challenges to Trump administration actions have already made their way to the Supreme Court on an emergency basis, and more are on the horizon, including oral argument on May 15th regarding the injunctions blocking President Trump's executive order on birthright citizenship. And of course, while there is this flurry of activity on the new administration's actions, the development of law in other matters doesn't stand still. The court term is full of important cases involving religion in schools, the ability of individuals to access gender-affirming care, separation of powers and independent agencies, access to justice, voting rights, and much more. Fortunately, we have with us today a brilliant panel to give us insight into all of these topics and much more. I'm delighted that we're joined today by Pamela Karlan, Kenneth and Harle Montgomery, professor of public interest law and co-director of the Supreme Court Litigation Clinic at Stanford Law School, Devi, director of the Washington, D.C. office and the Supreme Court and Appellate program at the MacArthur Justice Center, Deepak Gupta, founding principal of Gupta Wessler LLP and lecturer at Harvard Law School. And last but certainly not least, CAC's own chief counsel, Brianne Gorod. To moderate this discussion, we are fortunate to have with us again this year the incomparable Mark Joseph Stern, Slate senior writer. And so without further ado, I will turn the program over to Mark. Thank you so much.
Thank you so much, Elizabeth, and thank you to all of the many participants who are joining us today. I can't add much to those stirring remarks, and I want to get to our conversation. But I will just briefly note we've got a lot of cases to get through today. We're going to try to get through as many as possible. We will have time for questions at the end. We've divided the cases into a few different buckets. We're going to start with hot button issues. We're going to move on to access to justice, then separation of powers and Trump accountability, before finally, hopefully, wrapping up with the emergency docket or shadow docket cases that Elizabeth mentioned. And I guess I just wanted to say at the outset, most coverage of the Supreme Court in the media is about Donald Trump and the Trump administration right now. We have seen an immense amount of coverage and stories and reporting all about Trump's clashes with the lower courts and ultimately the Supreme Court, and a lot of speculation about what the Supreme Court will do, and we'll engage in some of that speculation today. But I think it's worth remembering that the Supreme Court is an independent branch of government with its own agenda that it is pursuing very rapidly and in some areas quite aggressively. And there are areas where that agenda overlaps with the current administration. There may be areas where it deviates, but I don't think we should lose sight of the broader projects that this Supreme Court has taken on for itself and the ways in which the Supreme Court is single-handedly reshaping vast areas of law that have a huge effect on American life and American democracy and civil liberties. We should not make the mistake of only thinking about the Supreme Court and the judiciary through the lens of the current president. We should remember that these cases we're discussing today, for the most part, didn't leap out of nowhere. They are the latest development in a sort of long effort to push the law in a particular direction. There are some cases in which the Constitutional Accountability Center may have encouraged the court to do so and push it in a direction toward justice and equality. There are cases where the Constitutional Accountability Center and some of the brilliant lawyers with us today have urged the court not to take certain steps that may have retreated from principles of justice and equality. We'll be covering some of all of these types of cases today, but it's something that's top of mind right now as we enter the final stretch, the home stretch of this Supreme Court term. Remember that the justices certainly have their own mission that they are on here. And it is a mistake, I think, to only look at it as whether or not they are standing up to or capitulating to Donald Trump, as important as that is. So having said that, we're going to start with two of the most hot button cases of this term, and Pam Karlan is going to guide us through them. Those two cases are United States versus Skrmetti and Mahmoud versus Taylor. Pam, would you like to take it away?
Sure. So first of all, thanks for having me. United States against Skrmetti is a case about whether uh, laws banning gender-affirming care for minors, care that mostly involves hormone treatment, whether those bans are constitutional. And Mahmoud against Taylor is a case about whether or not the schools in Montgomery County have to let students out of class in elementary schools when the teachers are reading books like Uncle Bobby's Wedding or Tango Makes Three or the like that present LGBT people as part of the normal give and take of society. I'll make a couple of observations about the cases. The first is that in Skrmetti, the justices had two petitions in front of them, one from the United States raising equal protection issues, and another from the parents of transgender kids raising substantive due process issues about the rights of parents to control their children's medical care and the like. And the court granted only in the equal protection case and not in the substantive due process case. And I think part of the reason they did that is it would look incredibly there would have to be a real kind of cognitive dissonance if, on the one hand, they had said the parents in Skrmetti have no rights, but the parents in Mahmoud against Taylor, who are culturally conservative, religiously conservative people, have a lot of rights to take their kids out. And so that's the first thing I'll note about the cases. The second thing I'll note about the cases is that the United States switched sides in the Skrmetti case after cert was granted and before the court has decided the case. But instead of saying, we're no longer bringing our petition, we no longer think the Sixth Circuit got this wrong, dismiss our case, they're staying up there, which I think is a signal that they think the court is going to uphold these laws. And then the last thing I'll say about Mahmoud against Taylor in these senses is here, again, the question presented is driving the court in a weird way, which is the only part of the free exercise test that's up in front of the court is, does it burden the parents' rights in some ways? Not whether the government should be entitled, regardless of this burden, not to have kids hopping in and out of classrooms. And here, too, I'll just make an observation about Mark, you made the point about the court's agenda, but the Trump agenda here is really quite striking, which is at the oral argument, Justice Jackson asked what I thought was a really telling question was if you say it's a burden for these kids simply to have to sit in a room while the teacher reads a book, then what happens to a government that puts a sign on a bus that says, we just want you to know, same-sex couples, you can go down to City Hall and get a marriage license, or puts up another piece of government speech that says, hate has no place in our community. We like all people equally. We support LGBT rights, or a Pride Day thing, or like, does that burden the bus rider's religious freedom because in order to get the benefit of being on public transit, you have to see this message? And the Deputy Solicitor General kind of doubled down and said, yeah, basically, yeah, that's a burden on religious rights too. So it's really striking, I think, how the court is thinking about these two issues and how it's manipulating how the cases are set up to move its agenda forward.
And I guess we should also note that the court took up Mahmoud very early on in the case, right? There's an underdeveloped factual record. It's
Yeah,
not
it's
really
entirely,
clear
yeah, it's
who.
entirely unclear which precise books and whether it's the teacher just has them on the shelf or whether they're being read. But the idea that it burdens your religious freedom to be exposed to ideas you don't like, I can just see um, all sorts of people making all sorts of religious claims about burdens and then pushing the obligation onto the government to come up with some really weighty rationale for why it's entitled to do the things government does every day.
Right, right. Before we move on from Scrimetti, could you just briefly talk about what the court did agree to consider? You talked about how there's no
So
parental
they're
rights
considering
issue.
just the Equal Protection Clause claim. And the question there is whether this law discriminates on the basis of sex. Because if you want your child to have puberty blockers for precocious puberty, or you want your child to have hormones to help develop their secondary sex characteristics consistent with the sex the child was assigned at birth, you can get them, and you can't get them based on the sex that was assigned at birth. And the state basically in the law says this is because we want people to like the sex they were assigned at birth. So it really does look like sex discrimination straight up. And as you know, I argued the Bostock case several years ago, in which the court said, of course, discrimination on the basis of transgender status is discrimination on the basis of sex. That was an opinion by Justice Gorsuch, who was notably silent completely at the argument in Scrimetti.
What do you think that was all about? Gorsuch's total silence.
I don't know because he's usually a very active questioner. And I think maybe he didn't want somebody to say when he was asking the questions, uh, uh, here's what you said, Justice Gorsuch. We're just asking you to apply what you said. And maybe he wanted to avoid having those kind of little taped nuggets on your when you do amicus with Dahlia.
Yes, yes. He's always thinking ahead to how he'll sound on our podcast. Do any panelists have anything to add to that before we move on?
I was just curious what Pam thinks. I mean, about this decision not to grant the substantive due process claim. Like, did that cut off an avenue that would have been more um, successful for the plaintiffs? And did it also cut off? I mean, there's the dissonance with the Mahmoud case, but it also cuts off an awkwardness for the conservative justices that if you just told someone, now, I'm not going to tell you what the issue is, but it's a situation where the parents want to do, something, the children want to do it, their physician, their minister wants to do this, and the state wants to intervene and say no, you can't do this thing with your and it's medical treatment. You might think that it was you'd be talking about a case with conservative plaintiffs traditionally. Um,
That's exactly why I think they didn't grant, because
mhm.
it would have a terrible look right up against Mahmoud, and it would box them in some ways when you have parents, for example, who want to send their kid to conversion therapy in the state. I mean, they have that issue bubbling up about, can a state ban conversion therapy? And the parents say, I want to send my kid to conversion therapy, looks a lot like the gender affirming care case on the flip side.
Mhm.
I mean,
And
that's my guess.
just to lift that up, Pam is alluding to a case that the court just agreed to hear next term, where it will decide whether bans on conversion therapy for LGBTQ minors violate the First Amendment, which is could have a huge impact since more than half the states have enacted these kind of laws. I want to move on to an equally fraught and disturbing case, I think, which Brianne is going to walk us through, which is called Louisiana versus Calais, which is this Supreme Court's grand return to the Voting Rights Act. Just 2 years after narrowly refusing to execute the Voting Rights Act, it looks like it might be back on the chopping block. Is that right?
I mean, I think what's notable in some ways about this case is the fact that we're talking about it at all, because this is a case that could have been really simple with a really narrow decision. And maybe it still will be, but you're right, Mark. There were definitely some really troubling comments that were made by various justices at argument. So just to set the stage really quickly, this is a case about Louisiana's congressional maps. In 2022, the Louisiana legislature adopted a map that only included one majority Black district out of the 6 that the state has, even though a third of the state's population is Black. So this map was challenged in federal court. 7 judges from across the ideological spectrum all concluded that the map likely violated Section 2 of the Voting Rights Act, which prohibits states from diluting the voting strength of voters of color. And so the Louisiana's map needed to include 2 majority Black districts. So Louisiana did that. It created a second majority Black district at the same time that it also advanced some political goals of its own. But that map was then challenged. And the district court, hearing that case, held that the legislature's actions were unconstitutional. They enjoined the new redistricting plan and concluded that its decision to create the second majority Black district, that's right, that's the district that all these other judges had said was likely required by Section 2, that its decision to do that while furthering other permissible redistricting goals resulted in a racial gerrymander. So that's just plainly wrong. The court basically incorrectly treated the legislature's stated intention to create the second Black majority district as virtually decisive evidence of racial predominance. If that were right, then basically any remedial map drawn by a state legislature in response to judicial findings of a Section 2 violation would trigger strict scrutiny. And that is just not the way the court's voting rights jurisprudence has worked. That's at odds with court's well-settled doctrine, which requires states to take account of race to ensure fair maps, which give citizens of all races equal opportunity to elect candidates of their choice. The district court also, I should note, discredited valid political considerations that also motivated the legislatures drawing the maps in the way that it did. And that, too, is at odds with Supreme Court precedent, which has said that states have to have some breathing room when deciding how to draw district lines. So as I said, this should have been an easy case for the court to just reverse based on well-settled precedent. But instead, what we heard at argument were some really troubling questions. We heard real skepticism from some of the justices that inclusion of these 2 districts may now make the map unconstitutional. And what was maybe the most troubling thing, I think, was that some of the conservative justices' questions did suggest even bigger trouble for the VRA on the horizon. Justice Kavanaugh, for example, reiterated this position that he's previously staked out, that race-conscious remedies like the VRA can't, in his words, extend indefinitely into the future. And so this position is wrong. It's at odds with the text and history of the 15th Amendment, which gives Congress the authority to enforce that amendment's voting rights protections. But what's really, I think, deeply concerning is his insistence on bringing up this point in a case that didn't raise it. It wasn't an issue. And it's really odd also in the context of Section 2 litigation, given that the test for vote dilution actually expressly includes consideration of current circumstances. So there was definitely a lot that was troubling here. And I think just thinking about the court's agenda, as you put it, Mark, and the agenda of the Trump administration, this may be an area where there is a very, very dangerous synergy, because we have the court making these troubling statements about the VRA, the possibility of making it more difficult for Section 2 plaintiffs to bring claims in the future, at the very same time that you have this new administration basically shutting down the voting rights section, assigning attorneys there to other divisions, directing the department to focus not on voting rights, but on purported voting fraud. So it is definitely a troubling moment, and it'll definitely be interesting to see where the court ultimately comes down here.
I have a question that I know you can't answer, but I'm going to ask it anyway. As we both now alluded to, it was just 2 years ago that the Supreme Court refused to kill the Voting Rights Act in a case called Allen versus Milligan that was very, very similar to this one. That Alabama had one majority Black district, a court ordered that it create another. The Supreme Court narrowly but emphatically agreed that Alabama had to create another district to ensure that Black residents were equally represented. Why, 2 years later, with the same justices and the same court, does it suddenly seem as though there is extreme hostility toward the VRA and hostility toward a precedent that this court itself issued less than 2 years ago? What did Justice Kavanaugh wake up on the wrong side of the bed?
I mean, I don't have an answer to that question. I'm curious if Pam or others have thoughts. I mean, it's always possible that I feel like sometimes you have justices who know they don't have the votes to go where they want to go. And so they kind of take out that energy at the argument itself. And so, the small optimistic side that I have left, hopes that maybe that's part of what was motivating some of Justice Kavanaugh's questions. And maybe this won't be going where it seemed like it might be going. But it is, I think, a really good question because, as I said, this case to be open and shut, after the court's decision just a couple of years ago.
I'm curious if any other panelists have thoughts on that. Oh, Pam, please.
Kind of two observations about this. One is the second part of the case, the second case that Brianne was talking about. The Supreme Court has mandatory appellate jurisdiction over those cases, and that means that this issue bubbles up every time in a way that a lot of other issues, once the court settles them, they're not going to take again. The second thing is, Justice Kavanaugh did the same kind of thing in his little mini concurrence in last year in the St. Louis Title VII terms and conditions case, which is he's got this idea that anytime you take race into account, it somehow violates the Constitution, including when you have a statute that says don't discriminate on the basis of race. And what worries me here is it's not just about the Voting Rights Act, it's about disparate impact generally. And we saw last week an executive order from the Trump administration saying, let's go after disparate impact across the board. And I wonder whether this is tied in with that in some way.
Do other panelists have thoughts? All right. Then Pam, I'm going to stay with you. Thank you, Brianne. We're going to move to Oklahoma Statewide Charter School Board, which is a case the Supreme Court heard just yesterday. So oral arguments are very fresh. And Pam, can you walk us through what this rather bizarre and upside down case is all about? I think you're still muted.
Sure. So I think most other states now, Oklahoma has a charter school program. And, these are public schools generally that are regulated by the government, but they're outside of the normal kind of school board system. And the idea is to have some innovation in the kinds of education you provide and the like. And Oklahoma's statute says that the schools have to be non-sectarian and non-religious. That is, you can have like a school that focuses on math and science, or you could have a school that's about public service, or you could have a school that's interested in the arts or the like. But what you can't do is have, St. Ignatius Loyola Catholic School, charter school. Those schools have to be totally private. And a religiously affiliated school in Oklahoma asked to be made part of the charter school system, and they were denied the right to do that. And the court has taken two questions up in front of it in this case. One is whether the state violates the free exercise clause when it excludes religious schools from its program. And the second is tied to that, which is if you do allow these schools in, do their pedagogical choices, like, for example, requiring the students to attend mass or teaching straightforward religion in the classrooms, would that become state action? What's interesting about this case is that the court granted certiorari in the case, even though Justice Barrett had to recuse herself because of her ties, apparently, to some of the lawyers in the case, which suggests that they had at least 5 votes to grant certiorari, because if the court granted certiorari and was split 4-4 on this, it would just be an affirmance by an equally divided court that Oklahoma's exclusion of religious schools is enough. What struck me about the oral argument yesterday is the belief of some of the conservative justices, and again, Justice Kavanaugh was very aggressive on this, who are acting as if it's discrimination against religion anytime you exclude a religious entity from benefiting from a public program, that this is somehow bigotry against religious schools, as opposed to simply saying we have public schools in the country, we have religious schools in the country. As far back as Meyer and Pierce in the 1920s, we said, if you want to send your kid to a religious school, you're free to do it, but the government doesn't provide religious schools. I wonder whether in some places that now allow charter schools, they're going to, if the court decides you have to allow religious schools in, they'll get rid of charter schools altogether rather than have a program that simply subsidizes huge numbers of parochial schools. And again, this goes back to the question Deepak asked me about Skermeti, and I wonder if he would have the same question here. Like, imagine that instead of this being a Catholic school, you had had a madrasa coming in and asking for, a Muslim school in a red state. Would the court have the same view there? And I just don't know.
Deepak?
Well, isn't that an inevitable consequence of a decision in this case, though? I mean, it becomes very difficult to then draw that line and to say, well, the state can. I think it is still the law that the state can't discriminate among religions.
Yeah, I mean, I think that's right. I think the one constraint which the court may not be fully may be relying on perhaps a little too much is whether you have a critical mass and an infrastructure to create those schools. That is, what are the chances that there would be enough parents and enough sort of infrastructure? In some places, there might be, but in a lot of places, I think they wouldn't. And I think they really do view this almost entirely through the lens of Catholic schools,
Mhm.
which a number
Yeah,
of them attended.
well, I was going to make that point. I think it's relevant not just to this case, but also to Mahmoud, that most of the justices attended themselves private religious schools instead of
Mhm.
public schools. And so, Pam said in the Mahmoud discussion or oral argument, there wasn't much, sort of attention to how disruptive this would be in practice to have to pull out individual students from individual classrooms anytime something that their parents could object to comes up. And it's because, that's not their orientation. Their orientation is their experiences. They were in these relatively homogeneous environments where everyone had the same sort of fundamental beliefs about religion. And that's just not the environment that most, students in our country, are in. And so I think to Mark's point at the top about these people are bringing their own agenda into this. They are, and they're also bringing their own personal experiences into the way that they think about all of these cases.
Yeah. Brianne, did you have something?
Yeah, I was just going to jump in really quickly to note that one thing that I thought was really interesting about the argument yesterday was the extent to which you saw the justices who were pushing back against the Oklahoma Attorney General relying on some of the court's recent free exercise cases. And these were cases that, at the time they were decided were rightly, I think, described as relatively narrow, relatively, because you could have imagined a more aggressive decision from this court. Cases like Masterpiece Cake Shop, which was the case about the commercial baker who refused to serve, develop wedding cakes for same-sex couples. That was described at the time as a really narrow decision. But Justice Alito was using that decision yesterday to, he said to the Oklahoma AG, you've got a really serious Masterpiece Cake Shop problem. You saw the Chief Justice using Fulton, which was a case from a couple of terms ago that was also a relatively narrow decision at the time. And so I think it's just, really interesting to see how the court is slowly but surely, using its very aggressive view of the free exercise clause to potentially create really, really radical shifts in the law, which is what I think, you would have if they ultimately say that you have to allow this religious school to be a charter school. And I think, also as we're kind of heading into the home stretch of the court's term and going to be watching what the court does now, it's just a good reminder that even seemingly narrow decisions can, depending upon how they're developed down the road, have pretty massive implications.
Such
And
a
I
good
can't
point.
imagine, I was just going to say, and I can't imagine that if you pile these cases on top of each other, that some parent would be allowed to send their kid to a Catholic charter school, but say, I want my kid to be able to leave the classroom anytime the teacher talks about, it makes a statement against artificial contraception. I mean, but if you took all of their cases and piled them on top of each other and you actually applied the doctrine, presumably because this is a charter school, any child in the district is allowed to go there. They can't exclude the child on the basis of their religion. And then the child is allowed to walk in and out of the classroom, and that way lies madness.
So I certainly agree. I just wanted to build on Brianne's point about the scope of a decision. I'm sure that the court will promise that what it's doing is narrow, but there are 46 states, including Oklahoma, that have charter schools, as well as DC, Puerto Rico, and Guam. All of those jurisdictions require that charter schools be non-sectarian and that they specifically be secular in their operations. That requirement is also enshrined in the federal statute that governs charter schools and distributes billions of dollars to charter schools. So while the court might claim that what it's doing in this case is narrow, it will have an impact on every charter school program in the country and effectively strike down a major federal statute, which is an issue that Justice Kagan had to sort of fish out from the Solicitor General, John Sauer, who argued in defense of the Catholic school here, and basically said, yeah, we know we're the Justice Department and we know that our usual job is to defend federal law, but we're just going to not defend this one because we think that charter schools have a right to be religious, which was usually it's a big deal when the Justice Department decides to stop defending a federal statute, but here it was just a footnote. We may return to these issues, but I want to move on to our access to justice bucket of cases and turn it over to Deepak for LabCorp v. Davis.
Great. So this is a case that I actually argued this week on Tuesday. And the court granted the case in January 24th, which was a day that I think most people were paying attention to all the crazy executive orders coming out that day. But the court granted this case and set it on a pretty accelerated schedule for this term at the same day that they granted the Oklahoma religious schools case. And it was a cert petition filed by Noel Francisco, who was Trump's Solicitor General in the first administration. And the cert petition, the question framed in the petition was whether or not class actions can be certified when they have some uninjured people in the class. So these would be people who would lack standing under Article 3 of the Constitution. And it's an issue the court has been dancing around for at least a decade. And the cert petition had pushed all the buttons of kind of the tort reform talking points that many of the justices are receptive to, that if you don't put a stop to these class actions where there are uninjured people in the class, they're stuffed with these uninjured people. It's unfair to innocent corporations, and greedy plaintiffs' lawyers are run amok. And then to make matters worse, the facts of the underlying case looked a lot I think, to some of the justices like a case that they had to toss off of their docket not long ago, a case about whether people who are asserting disability rights claims have standing. That was a case called Asheson versus Laufer. In this case, the plaintiffs are people who are blind and who are visiting LabCorp facilities. LabCorp is a medical testing company, and they rolled out a set of kiosks at these medical testing facilities that everyone acknowledges are not accessible to the blind. So they had the choice of picking a kiosk that was accessible, and they decided instead to pick one that was not accessible. And at the same time, they got rid of their front desk staff. And so for a blind person, and once I've started working on this case, I've started noticing this everywhere. If you imagine that you are not sighted and you encounter all of these kiosks, it really is a problem. You're not able to interact with kind of the infrastructure that increasingly people take for granted. So that was the nature of the claim in this class action. And the Ninth Circuit had upheld the certification of a class, and the question is, was that consistent with the Constitution? Does Article 3 itself create a freestanding barrier that precludes the certification of the class? And then also, does the rule about class actions, Rule 23, what are the standards for certifying a class if the Constitution doesn't preclude that? And I think it's also important to just emphasize that the court actually granted three class action cases this term, all from the Ninth Circuit. And two of them were dismissed earlier this term because they didn't actually present the question that the corporate Supreme Court practitioners that pitched the court on those cases had sold them on. One of them was a case called NVIDIA that I argued, a securities class action. Another was a case against Facebook about the Cambridge Analytica scandal. And I think what it shows is that the court is so eager to take on these cases that push all those buttons that I was talking about earlier, that sometimes that maybe the clerks are not really noticing that the cases don't really present the question. I think that is the case in this LabCorp case. What we argued is not only would it be a real sea change in the law of class actions to impose this new constitutional requirement, and you would really make a lot of class actions that are quite common now impossible or extremely difficult to certify because it's not possible at the time before you've actually done your discovery and done all of the proof to figure out who those people are that are uninjured and weed them out. But also that this case just doesn't actually present the question. There's no finding in the lower courts that anyone in these classes were uninjured, and our view is discrimination is itself an injury under the Constitution, and so every single person in the class in this case was injured. But then also, there's a pretty serious jurisdictional problem in the case where the actual order that LabCorp sought to appeal, the lower court said was outside the jurisdiction of the court. And so the pitch that I made an argument was, if we're going to be talking about the limits of the federal courts and their jurisdiction, maybe we should start with this case in this court, and the court doesn't actually have jurisdiction. And I was pleased to see, I'm superstitious and I never like to make any predictions about cases where I'm involved, but I was pleased to see that the argument, more of the time was spent in argument talking about these threshold jurisdictional problems that we raised than about some of the Article 3 questions. And so I think it's possible, which would be a really remarkable thing, that we might end this term with the court having granted three cases about class actions and having to toss out all three of them without actually deciding the questions.
It's so interesting. You mentioned that these corporations and the business lobby are sort of crafting these questions presented around cases that don't really fit them, that don't have the facts or the law behind them. And certainly they are to blame, as are the clerks who are maybe doing a quick read of this. But surely the justices, too, who are voting to grant cert without actually considering whether these cases will allow them to get where they want to go, shoulder some of the blame. It sounds like they're so hungry to sort of check these items off their list that they're willing to take up these cases and have the parties devote immense resources to putting on, oral arguments, only to realize, oops, we didn't actually take the case we thought. I was shocked by the dig in NVIDIA, less so the other, but it is a very unusual dynamic that's unfolding here, right?
Yeah, I mean, a dig, which is Supreme Court speak, translates into dismisses and providently granted, but it's Supreme Court speak for we screwed up. You
Yeah.
know, we caused all of these people to spend all this time briefing this. We spent time preparing for this argument. We never should have been here.
Yeah.
That happens, maybe once a term, maybe zero times a term. So for it to happen potentially three times, and there are other cases where this issue has been raised that are still on the docket. I think it suggests that there's a quality control issue with the court's screening function, but I think it also shows, these are big name Supreme Court practitioners at corporate law firms that the clerks are all planning to go work for and take bonuses to work for, and I think that when it hits all of the kind of pushes all the buttons that there just isn't the kind of skepticism that needs to be shown to these petitions. And I hope, my hope is that it will mean in the future that the court will be a little bit more skeptical of some of these petitions.
That's really fascinating. Before we move on, does
Can
anyone
I
have,
say just one
please?
thing about this as well, which is really kind of tribute in a way to Devi and Deepak in particular, which is one of the problems on a lot of these cases is also the disparity at the cert stage, which is there aren't a lot of people who come in at the search stage to do the briefs in opposition that can keep these issues out of the court and can point this stuff out. And so in a lot of these cases, you could have kept the issue out of the court altogether, but it's like the catcher in the rye. How are you going to keep all of these little kids from going off the cliffs? And Gupta, Wessler, and MacArthur are two of the places that will step in to do briefs in opposition to try and keep these issues out of the court. But there aren't a lot of places that will do that.
Yeah, Davey and I have talked about this. I mean, these are like my favorite briefs to write, and I think
Yeah.
there's
Oh,
a
I love doing briefs in opposition because it's like in 1984, take Julia, right? It's, do your damage somewhere else. But there's a real art to this. More so, I think, even than briefing on the merits, there's an art to keeping the case out of the court, and there aren't a lot of people who do it.
Yeah, and
Yeah.
it's the dark arts of of pitching the case in the court, and you have these very sophisticated practitioners with armies of recent clerks, and they know exactly what to say, to manipulate the court into taking their cases.
So, in addition to Deepak's note about maybe the court will learn from these maybe trifecta of experiences of, sort of buyer's remorse, um, I guess like it's also possible there might be fewer in the future or the near term because the court, I think it seems to be reserving a fair amount of its resources for these emergency docket issues that are coming up and are likely to continue to come up in the sort of near term future given the administration. And so, if the court's merit docket is shrinking in comparison to the space it's saving, there's probably less opportunity to do these like whoopsie grants as they're trying to fill out their docket.
Um, Great final point on this conversation, which could go on for much longer. But Davey, I have to turn it to you to flip us over to two different cases. You can talk about both or one, your choice. They are Barnes v. Felix and Martin versus United States.
Great. I'll try to do both, but quickly, because I feel like there's a theme for both of them. So I'll
Absolutely.
start with Barnes. So Ashtian Barnes was driving a rental car on a highway outside Houston. The rental car's license plate was associated with unpaid toll fees, but he didn't incur them. It was a rental car. The car is picked up on a toll camera and flagged, and an officer, Officer Felix, initiates a traffic stop. So Barnes can't immediately locate his license. Officer Felix then asks him to step out of the car. The car starts moving forward with the driver's side open. And in the span of 3 seconds, Officer Felix draws his gun, jumps on the car, and shoots Barnes, the driver, who bleeds to death on the side of the highway. So in the foundational case of Tennessee v. Garner, as I think many people on this call are aware, assessing force and whether it violates the Fourth Amendment is about the objective reasonableness of the force, given the totality of the circumstances. But in deadly force cases, the Fifth Circuit and a few others had applied a rule known as the moment of force doctrine, where they zoom into the specific instant in which the officer deploys the force and ignore sort of everything that happens before that. So here, the Fifth Circuit looked to the 2 seconds after Officer Barnes jumps onto the moving car and not the second before. He jumped onto the car to get a toll violator, who wasn't even a toll violator, from driving away. So the oral argument in this case happened in January, and I wasn't involved. So unlike Deepak, who's nervous about predictions, I will go ahead and say, based on what I heard, I would guess that the petitioner is going to win here, and that the court will cut back on the moment of force doctrine, which is, I think, good news for people who are subject to police violence. But Of course, there's always a but. Many members of the court were focused on not wanting to deter officers in the field from acting, sort of similar to the doctrine of qualified immunity. And so I would predict this is a narrow opinion. I'll win for civil rights, but probably a modest one. And in that vein, I'll turn to Martin v. United States, which is well, I'll just start. Okay, so the FBI had a warrant for a particular address in suburban Atlanta where a gang member resided. Before dawn, they arrived, except whoops, it was not the right house. They arrived at a different address. The SWAT team smashes the front door open with a battering ram, detonates a flashbang grenade, and rushes inside, terrifying the sleeping family, which included a 7-year-old boy. The family sues the United States under the Tort Claims Act for the tortious acts of these FBI agents. So generally, federal government actors have sovereign immunity, but in 1946, Congress passed the FTCA, which provides a federal cause of action for damages to allow a plaintiff to bring a state tort lawsuit against government employees. There are, however, 13 exceptions to that, including the discretionary function exception, which reinstates sovereign immunity for any claim based on the exercise or performance of a discretionary function or duty. Okay, so then in the 1970s, there were actually a couple of very highly publicized wrong house raids, similar facts actually to this case, which made national news. And the FTCA, as drafted at the time, prevented them from prevailing. So Congress amended the FTCA in response and added the law enforcement proviso, which re-waives sovereign immunity. It's back and forth, allowing people to sue to create a cause of action for intentional torts created by federal law enforcement. So the question in this case is basically how broadly this proviso extends and how, if at all, it interacts with the discretionary function exception that I laid out a minute ago. I will spare you the details of this case. There was a lot of back and forth at argument earlier this week about how broad the questions presented actually are and what is, sort of the order of operations in the case and what they need to answer and et cetera. But I will just say it seems like the Supreme Court, again, is inclined to say something that will have the effect of restarting the plaintiff's case, which was basically barred by the 11th Circuit's operation of how they interpreted the FTCA. But the court's likely to leave the bigger questions for the courts below. So again, similar to how I think Barnes is likely to go, this will be a plaintiff side win, but a small one. I'll stop there.
Could you briefly tell us what the 11th Circuit said?
Yeah, so the 11th Circuit had said basically that there is a supremacy clause problem with allowing the suit to go forward, which doesn't make a whole lot of sense, but it was a way of kind of like backdooring. The 11th Circuit had previously said the discretionary function exception is like narrow, relatively narrow, and doesn't preclude these types of suits. And in a sort of way around that, a subsequent panel says, oh, but there's a supremacy clause problem. Um, and then there's some dynamics where the SG's office sort of like wasn't willing to defend that, but then has this alternative argument. So there was an amicus who came in. I was trying to avoid all these complications, but it is a bit of a mess.
I think it's really important. And Brianne, I know that CAC filed a brief about the supremacy clause issue. I was wondering if you wanted to address why it's not actually an issue at all.
Yeah, I mean, it's really a very bizarre position that the 11th Circuit took. I mean, which is to say that the supremacy clause, which is in the Constitution to make clear that where there's a conflict between federal and state law, federal law trumps. What the 11th Circuit said was, well, even though this is a federal law, because that federal law incorporates state law, somehow that bars the Federal Tort Claims Act waiver of express sovereign immunity. It's really, I think it was not at all surprising that at the argument that was not a subject of a lot of discussion among the Supreme Court justices. I think, the 11th Circuit is a complete outlier in taking that position. This was just kind of a novel exception that this court adopted to try to keep people out of court. Really, as Devi says, makes, no sense.
I felt bad for the lawyer who had been assigned to argue for the 11th Circuit's position, who put up a valiant effort. But he didn't even get any questions. I think the justices couldn't even think of anything to ask him. The position made so little sense.
Was he court appointed amicus?
Yeah.
Yes.
Okay.
Yeah.
But the other thing about this that's so excuse me, so important overall is this question of whether when the government is violating the Constitution, they can even invoke the discretionary function exception. And there has been a split on this for years. We've tried taking it up a couple of times, haven't been able to, including in a case that involved the deportation of an American child by ICE people. This is now about 10 years ago. But it's a really, this discretionary function exception is a huge issue in these cases. And I just hope that the court doesn't muck it up.
Yeah,
Mm.
I just want to sort of end this discussion by saying, Deepak was talking earlier about the well-resourced, commercial bar. Uh, what's great about this case is it was very strategically lawyered, and the Institute for Justice Lawyers, who I know we partner with a lot, so does CAC. They're very smart and strategic about this vehicle. It is this almost identical fact pattern to the very case that precipitated this Congress to draft this language in the first place. And so, at oral argument, they were able to say basically, if you read it the way the government wants, you are writing out the very case that Congress wanted to allow these claims for. So I thought it was so well lawyered and a bright spot.
Excellent. With that, we will end our conversation of this bucket of cases and move on to separation of powers and Trump accountability, which are so often intertwined. But before we get directly to Trump, we're going to detour to FCC v. Consumers Research, and Brianne is going to take that one for us.
Yeah, I was going to say, so much of the legal news lately has been understandably focused on all the Trump administration attacks on the federal government and its ability to do its job. But this case is actually a reminder that these sorts of attacks really predate the current administration. I mean, there's been long a multifaceted campaign brought by the conservative legal movement and by industry to undermine federal agencies and the work that they do. And so one aspect of that campaign has been this effort to reinvigorate the non-delegation doctrine. In other words, to impose really stringent limits on Congress's ability to delegate authority to federal agencies. And I should say, if the court were to do that, it would have potentially huge ramifications for the ability of the federal government to function effectively across a whole array of issues, from protecting the environment, protecting workers, protecting consumers. The list could literally go on and on and on. The subject of this particular case is the Universal Service Fund. This is a program that Congress required the Federal Communications Commission, or the FCC, to set up to facilitate internet access for entities and populations that might otherwise have been able to afford it. So, schools, libraries, rural healthcare providers, and the FCC in turn created what's called the Universal Service Administrative Company, this nonprofit to administer the fund. So this program was challenged by this group called Consumers Research, and the Fifth Circuit held that this is unconstitutional. It said that both the grant of power from Congress to the FCC and from the FCC to the nonprofit that it set up likely violated the non-delegation doctrine. They couldn't say for sure, but it likely did. But that if you put those two things together in combination, those two delegations of power violated the Constitution. This, I have to say, is just completely wrong. We filed a brief in the case just focusing on the delegation from Congress to the FCC. We filed on behalf of two leading law scholars, Julian Davis Mortensen and Nicholas Bagley. And our brief explains that the Constitution's history and its original meaning simply do not support the restrictions that the Fifth Circuit wants to impose on Congress's ability to delegate authority to agencies. As we explained, these kinds of legislative delegations of authority were uncontroversial in the founding era. They happened in Britain. Nothing in the ratification of the Constitution imposed new restrictions on the ability of legislatures to delegate authority. The Constitution assigns legislative powers to Congress, but nothing about that assignment of authority limits in any way Congress's power to delegate policymaking authority to agencies, as long as Congress retains ultimate control over the legislative process. And you see this in early practice in the country. The first Congresses routinely delegated to the executive branch virtually unguided policymaking discretion over the most pressing issues facing the country. So, delegating broad authority to the executive branch was not only not rare in the country's early history, it was entirely routine. One thing I thought was actually quite interesting about the argument in this case was that, maybe surprisingly, you had the Trump administration defending the FCC here. It was the acting Solicitor General at the time argued that the statute left the key policy choices to Congress, was precise enough that courts could tell whether the FCC followed the law. You also had Paul Clement, who's like a conservative legal icon, representing a trade association for the telecom industry, also defending the program and talking about how disastrous it would be for beneficiaries of this program if the Fifth Circuit's decision were affirmed. And that is something he is certainly right about as well. So this, again, I think we're all nervous about making predictions about anything, particularly with this court, but it did not seem from argument like there was appetite in this case to kind of take the broad, aggressive step that some folks in the conservative legal movement and industry have been asking the court to take.
So oddly enough, this was another case in which nobody seemed to want to defend the decision of the court below, right? I mean, the Fifth Circuit's holding through Judge Oldham, who is one of the Supreme Court's favorite judges to reverse, it seems, was essentially that this is unconstitutional because it's two delegations, because it's a delegation from Congress to the executive branch through the FCC, and then another delegation from the FCC to this allegedly private group that sets the rates. And none of the conservative justices, as far as I could tell, really bought that. I mean, Chief Justice Roberts essentially made fun of it from the bench. But if you take out that argument, it just leaves you with this very vague hand-waving non-delegation claim, which, as you say, Brianne, is not at all rooted in history or tradition. I am curious, I agree with you that the court will likely shoot down this challenge. Are you worried that in the process, the court will articulate a new standard for non-delegation challenges that still opens the floodgates to more of these cases that might be successful in the future?
I mean, I think you always have to be nervous whenever the court says anything in this area. But I also think this is an area where I think the challenges are going to continue regardless of what the court says. I mean, what you would hope for is an opinion that makes clear that is, as I said and you said, like there's just no basis for this in the original meaning of the Constitution, and that would shut them down. But I think what we're likely to get is something that is much more narrow than that and just kind of maintains the status quo, and we'll continue to see these challenges coming up in the lower courts. But hopefully, this will at least send a message to the Fifth Circuit that it needs to stop engaging in, these games and providing these really, really aggressive opinions that, are so far to the right that even this very conservative Supreme Court is not willing to take the same position.
A message that the Fifth Circuit will not heed. But they can try. SCOTUS can try. Before we move on from this, do any other panelists have any comments or questions? Okay, great. Then I think that takes us back to Deepak for the independent agency fights, which I realize you are in the thick of at this moment. So please give us the background, give us the story, and feel free to sort of fill us in on exactly where things are at this moment, because I know that this is really very much ongoing and we could get some action from the Supreme Court at any moment.
Yeah, and so I'm going to do the same disclaimer, which is I'm not going to make predictions, but I'm really curious to hear what other people's predictions are. So my client is Gwynne Wilcox, and she was the chair of the National Labor Relations Board in the up to the start of the Trump administration, and is a member of the National Labor Relations Board. Or actually, the question in the case is whether she is a member of the National Labor Relations Board, because shortly after the inauguration, she received an email late at night from the White House's Presidential Personnel Office informing her that she had been removed. The email had typos. It also purported to remove the general counsel of the agency, who actually the president has the authority to remove, but the email invoked Article 2 of the Constitution. She is not alone. Kathy Harris, who was at the Merit Systems Protection Board, also received such an email. So did commissioners on the Federal Trade Commission. So there's a series of independent agencies where for nearly 100 years, the law has been that the people in these positions, the way Congress has designed these agencies, they are protected from removal. And for nearly a century, that is how it's worked under Supreme Court precedent, particularly a precedent called Humphrey's Executor. It's been widely understood. There's a settled interbranch understanding that Congress can design these multi-member agencies, particularly agencies that need independence because they are adjudicating claims or dealing with financial regulation that needs to be insulated from the political pressures of the day, that Congress can do that. And Congress has acted in reliance on that over and over and over again to craft agencies like the Federal Reserve Board and the Nuclear Regulatory Commission, and the NLRB, which was created at a moment where, you had labor unrest, you had violence, and there needed to be an independent, neutral body that could decide labor cases. So this is, Mark said at the beginning, there's a question about the agenda of the court and the conservative legal movement and how that might intersect with the agenda of the Trump administration. I think that's very much at the center of what's going on here, because up until the second Trump administration, I think that observers of the court thought the court was on the path to, chipping away at, and if not overruling, Humphrey's executor. And in a case about the Consumer Financial Protection Bureau a few years ago, um, the court held that a single director agency with for-cause removal protection is unconstitutional, but pointedly reserved the question about Humphrey's executor and multi-member bodies, and in fact distinguished those agencies based on this kind of traditional settled understanding that those at least are constitutional. But Trump has gone about this in Trumpian fashion, in the way that so many other things are happening in the second term, in this very, very aggressive way, where he's, firing people across these agencies, and at the same time is threatening the chair of the Federal Reserve, which, we believe makes, potentially the Chief Justice and some of the other justices pretty nervous about where this goes. Um, so we sought an injunction in district court, and this case moved up through the federal court system very, very quickly. We got an injunction from the district court, then we went to an emergency panel in the DC Circuit that stayed that injunction. Then we went to the en banc DC Circuit, which reinstated my client, and then now it's on the emergency docket at the Supreme Court, and it's been sitting there since April 9th. So how much of an emergency is it if it's been, sitting there for a month? And, um, you know, does the court think this is an emergency? Does the court think that it needs to jump in immediately? The Solicitor General certainly thought so. They asked the court to skip over the lower courts, grant certiorari before even waiting for the DC Circuit, and set oral argument for May. Well, it's May 1st now, so I think that that's unlikely. But I think most observers of the court think that this issue is headed to the court eventually. We think there are good reasons for the court to wait and to allow the issue to percolate a little bit. For one thing, the differences among these agencies really do matter. The National Labor Relations Board has an internal separation of powers. Um, it was created in 1935, but then later on, Congress actually amended the statute and took all of the prosecutorial type functions, all of the things you might think of as traditionally executive, and put them under the general counsel, who is removable and serves at the pleasure of the president. And so the members of the board are actually really just more like appellate judges who are deciding cases. And I think that it would be useful for the lower courts to weigh in the first instance about how these agencies are structured, and then give the court a menu of options if and when it chooses to take the issue up. But we could find out tomorrow or next week what happens in these cases.
And this is, to be clear, the unitary executive theory being pushed to the court, right? This idea that the president must have total power over the executive branch and total freedom to fire executive officials. I wonder if you could just sort of spell out, you mentioned the Federal Reserve. Could you just sort of talk about the consequences, the practical implications of the Supreme Court potentially, in this case or a similar case, embracing the unitary executive theory once and for all, and giving the president this absolute control that Trump so desperately seeks over every nook and cranny of the executive branch?
Yeah, I mean, it was, we say in our opposition to the government's application, it would be hard to imagine any precedent whose overruling would more radically upend existing institutions. If the court were to signal that it's going to overrule Humphrey's executor, it would overnight. It would prompt challenges, and I think cast a constitutional cloud over everything from, as I said, the Federal Reserve to the Nuclear Regulatory Commission, the National Transportation Safety Board, and then even courts. There are courts that are, Article One courts like the Court for Veterans Claims that are housed within the executive branch. And so, I think it would be tremendously destabilizing. And the court has stepped back from the step of overruling this precedent up until now. So I am actually someone who doesn't think this is foreordained what's going to happen here. And I think my hope is that the very, very aggressive way that the Trump administration has gone about this, and particularly threatening the Fed, will have an effect on the court, and that may be why they have been that application's been sitting there on the docket for a little while now.
Thank you. Do other panelists have anything to add?
Yeah, I had a reaction similar to what Deepak was just saying, which is I think if you had a normal administration in there firing the people from any one of these agencies, the administration might well win because the court would chip away in various ways at Humphrey's executor around the edges. But this administration has been so aggressive and has gone after so many agencies that really are mostly adjudicative or legislative in what their day-to-day work is, um, that I think they may have overreached here.
Yeah, I share that general optimism about what may happen in these cases. I mean, I think it's, worth underscoring the point Deepak made that, multi-member independent agencies have been around for an incredibly long time. And, even in the decision that Deepak referenced involving the CFPB, which had a single director head, the court essentially reaffirmed the legitimacy and the constitutionality of multi-member independent agencies. And so you would think if the court were going to turn around and overrule all of that history, they'd be able to point to really clear evidence, right? Like really clear evidence that this is inconsistent with the Constitution's original meaning. And I just think that they will not be able to do that. There's nothing, I think, from the founding that says that, even if the president has some power to remove, that Congress can't impose modest limitations on that allow him still to kind of exercise his take care responsibilities. So, which does keep the question then of like, what is going on now and why is the court intervening now? But I think that just tees up the larger question about the court and the shadow docket and the fact that it's intervening in some cases and not others and taking a long time with some and scheduling random arguments. And it's, I think, really hard to know like what the court is doing and why it's doing it, in part because it's not telling us and not providing the transparency about like any of the decisions it's making about when it does and doesn't intervene, at different stages as these cases move their way up to the lower courts.
That feels like a perfect segue into our last assigned case that we'll be talking about, which is JGG versus Trump. This case has many twists and turns. Devi, I'm not going to ask you to catalog each and every one of them, but could you just sort of give us the download on JGG and broadly speaking, what has happened over the last 6 weeks? It feels like a year, but I guess it's only been 6 weeks.
Yeah, happy to. And I guess I'll say, I think this is another example of where the rushed, broad, chaotic nature of the administration's actions is probably impacting, and what is going on external to the four corners of the case is probably impacting how the court is thinking about these issues. So there's a number of cases that have been sort of up at the court dealing with the president's use of the Alien Enemies Act, which everyone is familiar with now. So President Trump issued a proclamation invoking the act to detain and remove Venezuelan nationals, quote, who are members of TDA, Tren de Aragua. So a couple planes worth of people were removed to El Salvador's notorious CCOT prison. And in anticipation of continuing these removals, the government began moving Venezuelan migrants to a detention center in Texas. So the ACLU and Democracy Forward sued, representing 5 detainees in a putative class. This was styled as an APA claim. They argued that the Alien Enemies Act fails to satisfy the statutory prerequisites. So, among other things, there has to be a declared war with a foreign nation or government against the territory of the United States. So these all don't sound like what is going on in this context. And historically, the Alien Enemies Act has been invoked only in the War of 1812 and World Wars One and Two. So the district court in DC, Judge Boasberg, issued two temporary restraining orders. These are the famous orders where he, from the bench, said, I'm enjoining these planes from taking off, and also if they're in the air, they need to come back. They didn't do that. And then the defense is, well, you didn't say it in writing. So I'll bracket this. This is obviously a high profile, important um, potential constitutional crisis that is ongoing, but it has not reached the Supreme Court. But you can assume the Supreme Court justices obviously have been following it closely, and I think that plays into what's going on here. So, about the actual case, so the TRO is issued, and then eventually the government applies to the Supreme Court seeking to vacate these orders. So, April 7th, the court does vacate the TRO. It's a per curiam opinion. It appears both sort of on the opinions page of the court and also on this other page, sort of relating to orders. Very confusing. So first, the majority says that there is that these are appealable, which was a question that had been challenged by the plaintiffs. They didn't reach the merits of the interpretation of the Alien Enemies Act, but just said, not just, but said these need to be brought as habeas claims and in the place where these people are detained, meaning in Texas, not in DC. Um, the Supreme Court went out of its way to say here the government concedes that these people do get judicial review. And of course, that's important because it plays into the Abrego Garcia case, which everyone's familiar with. And there's a dissent from Justices Sotomayor, Kagan, Jackson, and Barrett who joined in part, talking about sort of how, in addition to all the other reasons this is a problem, it's all the more troubling because this is playing out on this emergency docket where they didn't sort of have full briefing or argument or anything. Justice Jackson wrote a separate dissent emphasizing this. And just two quick addenda to this case, which is it reached this sort of same issue reached the case in the court in a separate case because the plaintiffs get this order that says you need to go bring habeas cases in Texas, so they do. And it goes to the Northern District of Texas and then to the Fifth Circuit, eventually reaches the court, which issues this order after midnight on April 19th, which was a Saturday, directing the government not to remove anyone in this class until it receives sort of further notice from the court. And the final point is just the Abrego Garcia case, which has touched the court as well. So everyone's familiar with Mr. Abrego Garcia, the Maryland man, mistakenly deported to El Salvador, the one place a judge had said he cannot return to. The district court in Maryland told the government to facilitate and effectuate his return, which was concededly an error. And on April 10th, the Supreme Court issues another order, not an opinion, leaving in place that the requirement that the government facilitate his return, but saying, effectuate is too far. And so this is the case I think everyone should probably is also aware of. Judge Wilkinson and on the Fourth Circuit wrote a very eloquent, very impassioned opinion in this case, talking about sort of the executive branch needs to respect the judiciary, and we're clinging to hope, he says, that we're avoiding a constitutional crisis. He talks about the gears of, what was the metaphor? Gears of something grinding against each other. And now, the President Trump, I think 2 days ago, said he could get Abrego Garcia back from El Salvador, but he's a gang member, so he's not going to, which of course is the whole point. He has not had any process to contest the allegations that he is a member of Tren de Aragua, for which there is very little support. I'll stop there.
Thank you. Other panelists have thoughts on this?
There's so much that we could say about these cases, and I think probably of all the cases, these are the ones that people have been maybe following the most closely, and they've made headlines, been so dramatic. But to me, I mean, we were talking earlier about the aggressive nature in which the Trump administration is proceeding and how that's affecting the way the court thinks about the administration's actions. And I think the single best data point that it's having a pretty big effect on the court is that unusual 1 a.m. Order that Devi mentioned, because the only explanation for that order is tremendous mistrust that the court has now for the administration, right? Because they skipped over the district court and the Court of Appeals, and the administration was taking the position that they were not going to engage in these deportations. And given the experience with Judge Boasberg, and given also that the court itself had said, look, you have to afford process and you have to give notice, and they very clearly weren't doing that, or if they were doing it, it was just kind of an empty gesture, like here's a piece of paper as we put you on a bus to the airport. That's a pretty remarkable thing that in a short period of time, the administration has acted in a way that has, I think one way of putting it is they've sacrificed the presumption of regularity.
Yeah, and the other thing that's really striking about this is it's not just how incredibly irregular and lawless it is, but that the administration can't seem to hold itself together on this stuff, right? They go into court and they say it was an administrative mistake. Then outside of court, they make a totally different statement. Then they say we can't bring him back. Then the president says, of course, I could bring him back anytime I want. And they're sacrificing a huge amount of also their credibility in addition to everything else. It's not just regularity, which is about what's the administration doing out there in the world. It's also, do you believe anything the administration says about what
Mhm.
it's doing? And it's incredibly striking. And the order, the nature of the order is not just the timing, but it's like, don't deport any of these people, right? It's not don't deport them under the AEA. It's don't deport these people at all.
Mhm.
Because the government was kind of hedging on, well, what if we have another basis we could deport them on? Can we do that? And I just think, you kind of juxtapose this with something else that happened at the Supreme Court very recently that we haven't mentioned, which is the standing ovation, including the justices, for Ed Needler when he retired from the SG's office. And they are hemorrhaging credibility.
Mhm.
And people.
Yeah.
That's such a good point. I want to move on briefly to birthright citizenship, but before I do, you mentioned the Justice Department. We were talking about this right before the show. Does anyone have broader thoughts? We've mentioned this sort of again and again and flicked at it, but the way the Justice Department is approaching some of these cases, the arguments that it's making, the way it's treating some of these judges. Does anybody have any sort of thoughts or reflections on how the Justice Department has changed just in the 101 days since Trump has taken office, and maybe sort of a little bit more about the impact it's having on SCOTUS?
I mean, the Justice Department is hemorrhaging people. It's clearly, a lot of these executive orders clearly aren't going through the normal process that the regulations require, because it's impossible for me to believe that the Office of Legal Counsel actually reviewed them for legality. And so, they're shooting a lot of garbage up to the court.
Can I make a slightly different, I mean, I agree. I want to make a slightly different point, which is maybe one of the most outrageous, who's to say? Um, After the ruling at the Supreme Court about Abrego Garcia, um, President Trump was quoted saying, like, it was a 9-0 victory. That's what my lawyers tell me. That's what Stephen Miller told me, basically. Um, there's just no way you can characterize that as a victory for the administration. And so it is actually truly galling that the president is not even getting good information from his people. So the political choices he is making and sort of directing the Department of Justice to do is like based on just fake information about, sort of the status of these decisions and the rules that the court is putting in place. And so I imagine that is in itself a big problem that the court sees. Like he doesn't even know what these things are saying.
I mean, the Solicitor General has an impossible job right now, totally impossible job. They I think have tried to be somewhat restrained, and in the Abrego Garcia case, their filing to the Supreme Court said, this was a mistake almost simultaneously when the administration was saying the opposite. And I just don't know how long that is sustainable.
Yeah, and I was just going to underscore. I mean, you think about all of the credibility that the Department of Justice has historically had in front of judges and justices. I mean, the Solicitor General has historically been called the 10th justice. I mean, which speaks to kind of how much credibility that office has. But that's the kind of thing that can go away really, really fast when it becomes clear that the office is dishonest or is not getting good information from its clients and can't be counted on to really serve as an officer of the court and make good faith arguments before the court. And that I think could have really profound ramifications on how the justices and judges around the country treat what they are hearing from the Justice Department.
And when we start seeing oral argument in front of the court on these Trump issues, um, it's going to be really interesting because in the lower courts, the lawyers who are going in there are asked factual questions and they say, I don't know. I don't know. My client hasn't told me. And that is just not going to go over well at the Supreme Court. If they say, have there been negotiations with the folks in El Salvador to get, Mr. Abrego Garcia back? I don't know. That's just the court is not going to like that one bit. And I don't know. This is Deepak's point. It puts the office in an impossible position if the Stephen Millers of the world won't tell them what's going on.
I
I know
mean,
we could. Sorry, go ahead,
well, I was going to say, looking ahead to the argument on the birthright citizenship case and following up on Pam's comment, I think
please.
it's really difficult to imagine. I mean, obviously we've seen the briefs, but like how the government is going to argue that the Supreme Court should step in now and block lower court decisions that are simply maintaining a status quo that has existed, essentially since the 14th Amendment was ratified. I mean, even putting aside how clearly unconstitutional the birthright citizenship order is when you look at the text and history of the 14th Amendment. I mean, this is an interpretation that has been adopted by the Supreme Court. This interpretation being that there's a guarantee of birthright citizenship. It has been codified into federal law. It has been consistent executive practice for well over a century, and yet the department is now coming in and telling the court that it needs to intervene to step in to block lower court injunctions without even arguing that it's likely to succeed on the merits. I mean, it's just I think, incredibly strange position, and which also then raises the question of why the court is even hearing oral argument on it.
Yeah. I mean, so Brianne, before we get to a couple questions, you've brought up this last case, the birthright citizenship case. The Supreme Court will be hearing arguments on May 15th. We mentioned this a little earlier, but it's not actually clear that the justices will get to the merits. The question is, as you put it, whether the court will narrow injunctions against the Trump policy of revoking birthright citizenship for a very large class of people. There are 3 nationwide injunctions currently in place. What do you make of the court taking up the case in that way, in that posture, purporting to say, well, the main thing we're looking at is whether these nationwide injunctions were too broad and need to be made skinnier?
I do think it is really odd, and I'm certainly interested in others' views. I mean, I almost wonder if this is just almost of a piece with what Deepak was talking about earlier in terms of the court not always thinking the most carefully before it takes up cases and schedules argument. I mean, this question of nationwide injunctions is obviously something that is of great interest to some of the justices and something that they are preoccupied with and I think want to think through. But this just seems like a very odd place to do it. So I almost wonder if they thought nationwide injunction, let's go in here our argument and take on this issue. But then once they really think through what the government is asking them to do here, whether this is really the case in which they want to be taking that on. But I'm very interested in what everyone else thinks.
It was the government's strategic
Yeah.
decision to do this
Yeah.
thing. What they did is so odd. They said, they filed these 3 applications from the 3 cases and then said very little about the underlying merits and then, chose to make this the vehicle for the nationwide injunction issue, which is, an issue that's sort of present in many, many cases. They could have chosen any vehicle. And so I think it's, the court sat on this thing for quite some time. How long was it? Over a month before setting oral argument. And so I wonder if there's some significant disagreement in the court about what to do, and they haven't resolved that. And setting the argument on the applications is just like a way of dealing with that. There's no question presented. It's not an actual grant of cert, so nobody really knows what this is about. They could delve into the merits, and I think that might be a way of avoiding the injunction issue. It's mystifying, frankly. Like,
I think, that the government, my guess is that the reason the government took up only the injunction issues, that's the one they think they might be able to win. And
right.
whatever you think about the bar, I mean, I think the merits argument is pretty straightforward. But even if you didn't think that, the executive order is so clearly overbroad because it denies citizenship to children born into the United States, even to people who are lawfully present in the United States at the time. So people who are on student visas or H-1 visas or, tourist visas, or people from Canada who don't require visas at all. And there's no argument for that, right? Even if you have the kind of what's now, I think, the kind of cray-cray arguments that are coming out of the other
Yeah.
side. There's never been any suggestion. That's exactly what Wong Kim Ark's parents were at the time he was here.
Yes.
They were lawfully present in the United States, ineligible for citizenship people who had a baby. So my guess is that if this were a normal administration and a normal SG's office, they wouldn't have taken any of this up. But with this administration, they have to take something up because Trump is losing in the district courts and he wants them to appeal this. And so they came up with this, let's go after okay, only in I mean, some of their argument is truly loony, which is maybe you could have an injunction that creates birthright citizenship in 23 states, but not in the other states, because only the states that actually sued, that's their kind of fallback position, should have this, it should continue with, as Brianne points out, the rule that we've had for 100 and X years. But that's a lunatic position.
And the administration chose in rolling out this policy to do it only on a prospective basis. But the constitutional logic of the position that they're taking isn't limited to that approach, right? And so actually, like my mom was, I would not have my citizenship could be taken away under the constitutional logic of that position. It's
Well,
crazy.
and the other thing is, I think everybody's citizenship can, unless you've got somebody's naturalization papers that you can trace your descent back to, right? I mean, I'm a fourth generation American. So my birth certificate said I was born in New York, but it doesn't say anything about my parents' citizenship. My parents were born in New York and New Jersey, but it doesn't say anything on their birth certificates. My grandparents were born in this country. It doesn't say anything there. I have to go back to like the ones who escaped the Tsar's army in the 1880s and 90s to show that I'm entitled to be here. I mean, that can't be the correct position on, can people get a passport now by showing their birth certificate?
And if you're wrongfully deported, the logic, whether or not you're a citizen, the logic of the government's position in those cases is they can't and don't have to do anything to bring anyone back and give them process. So it's
Right, right.
scary.
So I'd love to just get at least one question in from our wonderful audience. Thank you for listening in and joining us. Before we go, I have a question from Steve Mazie of The Economist, and he asks, regarding the court only taking up the equal protection claim in Scrimeti, why did Justice Barrett suddenly start asking questions about the substantive due process claim of parental rights? If Barrett wanted to grant on that issue, she presumably could have with the three liberals. So why did she bring it up?
I don't know. I don't know why. I think some of it is, of course, that oral argument. You had the lawyer for the parents up there arguing, although only on the equal protection issue. But I just don't know. I don't know if one of you has more of a sense of why all of a sudden.
I have no idea either. I think that she doesn't want to be seen as a hypocrite, would be my best guess. And that she knew at that stage that she's going to be ruling for parental rights in other cases, maybe as soon as this June, and she did not want to strike the position that you were describing, Pam, where the court could potentially say you don't have a right to direct medical treatment for your children, but you do have a right to march them out of the classroom before they see a book about gay penguins. Like I think that she is cognizant of her image and cognizant of her reputation as being extremely into parental rights and in the realm of religious freedom, and perhaps wanted to get out there during arguments something that would produce headlines. Oh, Justice Barrett considers the possibility of a parental rights claim down the road, without actually committing herself to it. That's the best guess I could do.
Yeah, makes sense.
One more question from Stephen Hayes of the Dispatch. He says, reacting to the religious freedom issues noted at the top, could an entity focused on providing services to underserved communities like women-owned businesses argue that providing those services and redressing historic segregation and discrimination are part of its core religious values and mission, and therefore it cannot be subject to discrimination suits under civil rights laws?
So the answer to this is sort of yes, you can make the claim. How the courts are going to approach the claims when what you see is liberal religion groups making the claims is, this is why the fact that Mahmoud was only up there on does it burden and not on whether the burden's acceptable. I mean, there are all kinds of claims that people who are liberal and religious could be making. I mean, I think about Reverend Barber's entire movement is about these issues. And then the question are the courts going to say, yes, it does burden you, but the government has a sufficiently important interest that it overrides your religious objections?
All right. Well, we are at time. So with that, I want to thank the Constitutional Accountability Center for putting on this fabulous event. I want to thank our brilliant panelists, and I would like to thank the audience members for staying with us for all of this. This has been a really great, edifying discussion, a little bit terrifying, but that's just how it goes with the Supreme Court these days. And I look forward over the next 2 months to seeing how some of our predictions come true or not. And hopefully we will all be back here a year from now to talk about how much better everything has gotten. So thanks all.